One of the odd features of modern legal systems, both Anglo-American and European, is that they are redundant. They have two systems of law for doing the same work in different ways. Somebody breaks your arm, you call a policeman, he gets arrested. Someone breaks your window, you call a lawyer, he gets sued. In each case, you do something which I claim unjustly injured me. I go through a legal process, something bad happens to you, that's a reason not to do things that hurt people. One of them we call tort, one crime. And the point was, I think, brought home to some people, especially in America, when a retired sports star, O.J. Simpson, was first acquitted of the crime of killing his wife and then convicted of the tort of killing his wife. Which sounds odd, but since the standards of proof are different in the two systems, it's not all that surprising that in criminal law it's supposed to be beyond a reasonable doubt, in tort law by a preponderance of the evidence, which is a weaker standard. And so this raises a group of interesting questions. The first one is, do we have to have both tort law and criminal law, or could we manage with only one of them? And I think the answer on the historical evidence is that we do not have to have both of them. There is a historical society, a very interesting one, which managed for about a third of a millennium with a legal system in which if you killed somebody, his relatives sued you. There is another society which lasted for much longer, perhaps 2 millennia or close to it, in which if I lent you money and you didn't pay it back, there was no way I could sue you to get the money. All I could do was report you to the district magistrate as a swindler and hope that the district magistrate would try to make you give me the money back. The first society is Saga period Iceland from about 930 to 1263. The second is Imperial China from about 0 AD, though we don't really know the details that far back, to about 1900 when the last dynasty collapsed. So we know you don't have to have both of them, but that still leaves open the question, is it a good idea to have them? Are there some offenses that are better handled by criminal law and some by tort law? Or is it just some sort of an odd historical example, historical accident? And I am more intrigued by the idea of a pure tort system. It's a more decentralized, less government-oriented system. So I think of this in terms of the question, should we abolish the criminal law, which makes a good title for getting people interested, and then try to think about if we treated all things we now treat as crimes, at least the ones that we wanted to do anything about, as torts, would that raise problems? And there are a series of arguments that can be made, that people have made, for why you can't use tort law to handle criminal law. Part of the reason I originally got into reading up on Iceland was that there had been an exchange among some prominent economists and legal scholars in one of the journals on something along the general lines of replacing criminal law with tort law, though it wasn't quite put in those forms. People had, this is why you can't do it. Here I discovered a society that did do it, and that obviously raised some interesting ideas. So let me start with one of the arguments that's routinely made, and that is, what if I am the victim of an offense, but I am a poor person, and I can't afford to hire a lawyer to sue the offender? So that's the problem of the poor victim. If I think about it in the Icelandic context, the issue is not so much can I hire a lawyer, but do I have friends who will fight for me if I have to? Or can I be bullied or threatened or in various ways kept from asserting my legal rights? And it turns out that the Icelanders more than 1,000 years ago solved this problem. And the solution was to make a tort claim a marketable item. So if you have wronged me, and if I could only get my rights, you would owe me 100 ounces of silver. But I don't have the resources to get my rights. Well, I go to my neighbor, and my neighbor is a big, strong man, he's a successful farmer, and he's got 4 tough sons who went Viking in their youth, and still have swords hung up. And they've got friends too. And I say to him, look, my claim is worth 100 ounces of silver, how about you prosecute the claim and you keep half the money? And then he prosecutes the claim, he collects 100 ounces, I get 50 ounces, And even if he insists on the whole 100 ounces, I've still done as well as under a criminal system where I don't get anything either, because I've made the person who injured me pay for injuring me, and that deters people from injuring me. And I've been arguing for some time that in this particular respect, the current American legal system is a mere 1,000 years behind the cutting edge of legal technology, that making tort claims marketable would in fact solve a good many of the problems in our legal system. And I won't go into details on that. But my point at the moment is merely that marketable tort claims provide a way in which poor people can still get their rights defended in a pure tort system. Now there's a second argument that's made, which makes more sense if you don't think about it than if you do. And that's that crimes have a dispersed effect, because not only do I get mugged, but all you people are afraid of being mugged. And then the argument is that a private law system will only take account of my interests, whereas the criminal system can take account of everybody's interests. And the first problem with that is that does not distinguish crimes from torts. Because after all, not only might I be afraid of being mugged, I might be afraid of being run over, and that's usually a tort. I might be afraid of having a contract violated. Why are all those handled in the civil system? In fact, I think that in the case of mugging, as most other things, there is an identifiable victim. That victim bears a large part of the cost. Furthermore, if you handled mugging through the tort system, other people will be less afraid. You need this for recording, because in a room this side, I do not need a microphone. Are you recording it? Oh, there's another room. I'm sorry. All right, I'll try to use this later. That, after all, in a tort system, it's true I'm afraid of being mugged, but on the other hand, there is a compensation, which is that after I sue you for mugging me, I've got some money. Indeed, there's a bumper sticker you occasionally see, which says, "Run into me, I need the cash." In a criminal system, on the other hand, if you mug me and you're convicted, I get nothing. So if anything, the problem of other people being afraid of it happening is less in the tort system than in the criminal system. But in fact, I have a more general solution to the problem of dispersed injury, because it is currently a problem in the tort system. That there are some torts which do a little damage each to a large number of people. We currently, at least in America, handle this through class actions. And they work very badly. Because the way a class action works is that an attorney goes to a judge and he says, here are 4 people who have been injured. There are another 100,000 people who have been injured, but I don't have them here. I want to sue for all 100,004. And the judge sometimes says, all right, I agree. We need to get justice against the people who've done something bad to you. The class is certified, and you may sue in behalf of all of these people. And oddly enough, the outcome of this suit is a settlement. And the settlement is one in which the company that's being sued agrees to pay me, the lawyer, $100,000 for my expenses. And it agrees to pay my clients $1 million, but not in money. The $1 million will consist of offering anybody who was injured in this way a $10 discount on the next product they buy from the company. And thus, the victims have gotten $1 million, I've gotten $100,000, and we are all happy. And you can see that the difficulty with this system is that I, as the attorney, have no real incentive to act in the interest of my clients. I have an incentive to act in my own interest, and except to the very limited degree that the judge can keep me from doing it, I'm likely to settle in ways that benefit me and not the clients. There is a solution to this problem, and the solution is the Icelandic solution carried one step further. Let us not only make tort claims marketable, make them marketable before they happen. So when I am engaged in some transaction, buying auto insurance, say, the seller says to me, we'll give you a $25 discount if you agree to transfer to us any claims you may have in the next year for less than $100. Because after all, you're never going to sue anyone for less than $100 anyway. And after this has been going for a while, Now there are many millions of such claims held not by the original people, but by those they've sold them to. Now you're an enterprising lawyer, and you discover that someone has done something wrong to 1 million people. So you go to the owners of these packages of claims, and you say, I don't want to buy your whole package. Suppose the tort has to do with asbestos. All I want to do is to buy out the asbestos claims from all of the packages. And now I, as the lawyer, actually own the claims of 300,000 people. I sue for my own rights, because I'm all 300,000, legally speaking. I've got their claims. No problem of a conflict of interest. I'm doing it in my own behalf. And the victims get compensated in the market value of the claims they sold, rather than through any process by the court. So this is essentially a market-based solution to the dispersed injury problem, and one which works provided you make tort claims transferable. All right, there's another problem, and this is perhaps the most serious of them, and that's that it does no good to sue somebody if he can't pay anything. And this is what people in the legal profession refer to as a judgment-proof defendant. Someone where you get a judgment saying he owes you $5,000, and he says, well, I'll empty out my pockets, here's 50 cents. And there are a number of possible solutions to that problem. To begin with, the judgment-proof defendant is really two different problems. One of them is that you're not punishing him because he isn't paying any money. And the other is that since you're not getting any money, you have no incentive to go after him in the first place. All right? Because notice that in a tort system, the tort damages are really playing two different roles. They are both the punishment to the tortfeasor and the reward to the enforcer. If you think of the victim and his lawyer as being the enforcers of the law under a tort system, it really is a private law enforcement system in that sense. So for the first problem of no punishment, the Icelandic solution basically was, if you don't pay your fine, we outlaw you. If you have been outlawed, you have 2 weeks to get out of Iceland. If you don't, it is legal to kill you and illegal to protect you. Now, this has the result of giving people a strong incentive not to be judgment-proof. And one of the points that's often ignored in these discussions is that being judgment-proof is not purely a fact of nature. That in America, for example, if you are a wealthy person and you're about to lose a tort suit, what you do is to buy the most expensive house you can in Florida. Because Florida happens to be a state where your home cannot be seized for a tort judgment. Even short of that sort of device, most people have friends. Most people have other people who perhaps trust them or have ways of putting pressure on them. And if the result of not being able to pay your damages is something very bad happening to you, then you may find people who can lend you the money to pay the damages. Whereas if we say, well, you can't pay it, too bad, go home free, then you have an incentive not to try to raise the money. The Icelanders actually had a second solution, and that was what was called debt thraldom, which was essentially a temporary slavery, an indentured servitude, while the convicted defendant worked off his sentence. There are problems with that, I should say. This is something which occurred to me long after I did my work on Iceland. But the problem with any system, in fact, the problem with torts in general, for tort law as well as for criminal law, is that you have to worry that with a sufficiently corrupt court system, you will get people sued not because they did anything wrong, but because you want to collect the damages. And that's the problem people worry about now with punitive damages and class actions and so forth. It's no more a problem for current criminal law than it is for current tort law, but it is one disadvantage in general to tort law, that a punishment which benefits somebody, you have an incentive to impose even when the person isn't guilty, if you can persuade the court to do it. Let me discuss the second judgment-proof problem, and that is, what's the incentive to prosecute somebody if he can't pay? After all, I should say the modern version of the Icelandic system would be that if the defendant in one of my crimes turned into torts can't pay, we turn him over to the state and they lock him up for whatever the criminal punishment would be. And that gives him an incentive to be able to pay. We don't have to actually outlaw him because we're not used to killing people the way the Icelanders were when when they have mistreated us and not paid for it. The second problem, though, is the incentive to the victim to prosecute the crime. Because if I'm not going to collect anything, I don't get any money when they lock him up. It may be quite costly to find out who committed the crime, to prove it to a court. Why should I bother? And there are a number of possible solutions to that problem. One of them would be to combine a tort system with a bounty system. To say, look, the government no longer has the cost of hiring policemen, because now it's the victim who's finding out who did the crime, or the victim's employees, a private agency perhaps that the victim hires to catch the person who committed a crime against him. So the government can take a bit of the money they save and say, look, if the criminal can't pay his damage payment, then the government will not only take the criminal and put him in jail, they will also pay his damage payment in order to reward the victim for having brought in the criminal. So that's one solution. But there's a more elegant and more private solution. And this is one I discovered when I was reading up not on Iceland, but on 18th century England. Because 18th century England turned out to be quite an interesting society. On paper, they have a modern legal system. They have tort law, they have criminal law. A crime is treated as a crime against the king. I assume all of you know that it is impossible for any of you to be the victim of a crime. Legally speaking, it's impossible. At least it is in the US. I assume it is in Poland. That if somebody mugs me, when he comes to court, the case will not be Friedman versus Smith. It will be the state of California versus Smith. That legally speaking, all crimes are crimes against the state, and the victim is merely a witness. Right? In a tort case, it's Friedman versus, because that's treated as an offense against me. So in England, they had a distinction between a criminal case, which ended up as Rex v. Smith, and a civil case which ended up as Jones v. Smith. The only thing is they didn't have any policemen or public prosecutors. So that meant that although the crime was officially a crime against the king didn't in fact have anybody with the job of catching the criminal and prosecuting him. And the person who did that, legally speaking, any Englishman could prosecute any crime. And in practice, that meant the victim, just as with a tort case, or people acting for him. And when I originally read up on this system, I wrote an article on it, which is on my webpage with much else. The obvious question is, why did the victims bother? Since this was criminal law, so even if the criminal had resources, they couldn't get them. All right? When he's convicted, he doesn't know any damages to anybody. And there are a couple of answers. One of them is that you prosecute someone in order to be paid to drop the charges. That it's essentially a form of sort of extortion for an out-of-court settlement. But the other is, well, the next solution is reputation for deterrence. If I'm a likely criminal victim, if I've got some business which is an easy target of theft, then the fact that the last guy who stole from me ended up getting hanged is going to make it less likely that the next guy will steal from me. But most people aren't in that position. Most people are not likely repeat victims. They aren't going to be able to establish a reputation. And for those people, the English came up with a very ingenious solution, which was called an association for the prosecution of felons. And there were literally thousands of these in different towns in England. And the way it worked was that the members of the association chipped in an annual fee of £1 or something a year. And the fund that this made up was then used to pay the cost of a prosecution of anybody who committed a felony against a member of the association. Now, so far, it just sounds like insurance. The final step is that the list of members of the association is published in the newspaper for the felons to read. So that what it really is not insurance, but pre-commitment. That after I've been robbed, it doesn't pay me to go after the thief, because it'll cost more to catch him than anything I will get from it. Before I'm robbed, it pays me to set up things so that I will go after the thief, in order that the thief will know that and won't rob me. And by joining an association for the prosecution of felons, I create a situation where the money has been paid in advance, commit a felony against me, somebody hired by the association will prosecute you, therefore you'd better commit your felony against someone else. So that system pre-commitment to deterrence, or putting it differently, making deterrence a private good instead of a public good, is a way in which you can have an incentive to prosecute even if you can't get any money by winning the case. And you could easily enough imagine in a pure tort system that the potential victims would in effect sell their offenses in advance to firms in the business of catching criminals, and then if the criminal was caught and could pay his damage judgment, they get the money. If not, they don't, and the price that you sell your offense for to an enforcement agency could be either positive or negative. If it's a positive price, that means that on average they collect enough money to pay the cost of catching criminals. If on average they don't collect enough money to pay the cost of catching criminals, then you pay them because you're getting deterrence, and they give you a sticker to put on the door to warn criminals that you're a member of a prosecution association, essentially. So that's a way in which you could do that. Now, there are undoubtedly other potential problems to a pure tort system of this sort, but instead of discussing those, let me run briefly through some of the advantages. And the first, of course, is the general advantage of private voluntary market systems over socialist systems. That we don't usually think of our legal system as socialist, but of course it is. Socialism is government ownership and control of the means of production. Who owns the police cars? The government. Who employs the policemen? The government. Who runs the courts? The government. That is a form of socialism. It's a very popular form of socialism. It's true largely of most societies, not entirely. If you look at how international dealings are conducted, to a large extent, the law there is private arbitration, and to a large extent it's enforced not by threats of force, but by reputation. But within countries, we normally have a socialist system for making laws and enforcing laws. And what I'm describing so far, as some of you know, I'm in favor of entirely privatizing that, but that's not what I'm talking about tonight. I'm just talking about a modest step in the direction of abolishing the police force and criminal law, and turning all of that over to the victim and the victim's agents. And you would expect that private firms that were in the business of catching criminals and deterring crime would probably do a better job of it at a lower cost than governments would. So that's one reason. But a second reason is that the present system is a rather dangerous one. Because, after all, the government that is controlling criminal law may or may not be on your side. One of the things I wondered about when I was studying the English system was why the English did not adopt a modern system with professional police and prosecutors. And it's not that they didn't have the idea, because France in the 18th century was a modern society in this respect. They had prisons, they had police, they had public prosecutors. Now, of course, one explanation of why the English didn't do it until the 19th century is that the English didn't do it because the French did. And of course, any Englishman knew that if it was French, it had to be banned. But I have a different theory, and it's just a guess. And that is, if you look at English history, you will notice that the 17th century is a period of civil war, military dictatorship, and coup. All right? There's a civil war in 1640. It ends with the king having his head cut off. There's a second brief civil war between the people who won the first civil war and their best general in his army, which Oliver Cromwell and the New Model Army win. You then have a reasonably competent and benevolent military dictatorship by Oliver Cromwell for whatever it was, 10 or 15 years. He dies, his son's an incompetent wimp, so there's a coup d'etat by one of his generals to reestablish the monarchy. That monarch doesn't turn out very well. When the Stuart king dies and his brother, who is Catholic, is going to succeed, there's a coup d'etat that the English call the Glorious Revolution of 1688, and they throw out the Stuart king and import a king from Holland, William of Orange. It was the time when it was prudent to be careful about what you did in politics, because whoever was running things this year might be on the run next year. And I think it may have occurred to the English after that experience that if the criminal law is controlled by the king's friends can get away with murder. And that there is therefore much to be said for a legal system in which it's not in the hands of the authorities. And I think the same thing is true in our society. I think I'm a little short of time. I won't go through the details now, maybe I will later, but I know of at least 4 cases within my lifetime where government agents did things that were pretty palpably illegal, and indeed, I think in all 3 cases criminal. And in only one of them did any government agent ever get tried for anything criminal, and he was acquitted. That's not quite right. The other one, nobody was ever charged with the crime of murdering 2 people, which is what they did, but one of the people higher up in the hierarchy was charged with covering it up afterwards, but he got acquitted. That was the Black Panther shooting in Chicago when I was a graduate student. When the police came to the door of an apartment at night and opened fire and killed 2 people. But anyway, there are other cases. The most recent case was the present administration. There was a law which said that if you wanted to wiretap conversations between the U.S. and abroad, you had to get a warrant from a special court, and that wiretapping without that court was a felony, punishable by up to 5 years in prison or $10,000 in damages, and that knowingly using information obtained by such a wiretap was the same felony. President Bush instructed the National Security Agency to ignore that law. They wiretapped. He used the information. He didn't tell anybody until they got caught, at which point there were various arguments. But there is no chance that any of those people will go to jail, even though the law says 5 years and $10,000. So I think you have a freer society if larger parts of the enforcement of the law are in private hands and smaller parts in state hands. Of the cases that I know of, in fact, the Black Panther shooting, nobody went to jail, but the city of Chicago, the Cook County, and the state of Illinois paid a sizable sum in damages to the survivors of the attack because they could sue, and they did sue. The Steve Jackson case, which was a much less unpleasant case, but was nonetheless a clear violation of federal law by the Secret Service. Nobody went to jail, but Steve Jackson collected damages from the Secret Service. Ruby Ridge case, again, there was a damage settlement. The NSA wiretapping case, not that we've gotten no result at all. There were private suits against the phone companies for a different part of what the NSA was doing, which was against the law. However, Congress stepped in and immunized the phone companies from tort damages for having broken the law at the request of the government. So the basic argument is that you are likely to have a freer society if less law enforcement is in the direct control of the government. They still have the courts, they still have the legislature. I'm not talking about a fully private society, but only one at which you can't simply let people off by never bothering to prosecute them, which is what's likely to happen. Few final comments. First, for those who are sort of seriously interested in legal matters, there are 2 more interesting questions about tort law versus criminal law. One of them is, does the current division of what we treat as torts and what we treat as crimes make any sense? Second, in the Anglo-American system, and I suspect in the European system, the legal rules that apply to torts are different from the legal rules that apply to crimes. Is there any good reason for those differences of legal rules? People who are curious about these questions, I happen to have written a book which discusses them. The book is called Law's Order, and it's a general book on using economics to understand the law, and one chapter is called The Crime-Tort Puzzle, and deals with this whole set of questions. And if you feel like going to Amazon.com and buying a copy of the book, that's fine, I'll get $2 or something. If you don't feel like doing that, the entire book is on my webpage, and you can read it there for free. My webpage is www.daviddfriedman.com. That's Friedman, F-R-I-E-D-M-A-N. The book also, the webpage also has the entire text of my most recent book, which is about future technologies, and the entire text of a price theory textbook that I wrote many years ago, as well as most of my articles and essays and such that anybody who's interested is welcome to.